In February 2024, Justice Idit Abdullah of the Singapore High Court found Dr. Goh Jin Hian, son of former Prime Minister Goh Chok Tong, liable for breaches of directors' duties in relation to the now-defunct Inter-Pacific Petroleum Private Limited. The court held Dr. Goh, who served as a director of IPP from June 28, 2011 to August 20, 2019, responsible for the company's significant financial losses. IPP's liquidators had sued Dr. Goh for $156 million in damages, accusing him of sleepwalking through his time as a director and alleging that his negligence in overseeing the company's operations allowed it to become involved in fraudulent activities. The claimed losses included $146 million from cargo trading operations and $10.5 million from bunkering operations, incurred during a period when IPP was reportedly balance sheet insolvent. In a brief ruling statement issued on January 24, Justice Abdullah emphasized the responsibilities of a director, stating, "The obligation is to monitor the affairs of the corporation. This entails, among other things, at least a broad level of supervision of the activities of the officers of the corporation, for the protection of the company, its shareholders and creditors." Justice Abdullah noted that while directors are not expected to manage daily operations or scrutinize every minor detail, they must maintain an active role in oversight. Addressing Dr. Goh's defense regarding the adequacy of information provided within the company, Justice Abdullah stated, "The information was insufficient to address or dispel the significant financial concerns that arose. An honest and reasonably diligent director would have conducted a more thorough investigation into these matters." Between 2017 and August 2019, Dr. Goh held 36 concurrent directorships. In 2020, he stepped down as the non-independent, non-executive chairman of New Silk Routes Group, a healthcare and energy firm, and resigned as an independent director of Cord Life Group, a cord blood banking firm. The judge established that Goh is liable for the significant financial losses suffered by the company. Justice Abdullah affirmed that due to Goh's failure to act upon several red flags, which emerged as early as February 7, 2018, he should bear responsibility for the entire loss incurred during the period of June to July 2019. This loss amounts to a staggering $146 million, along with the interest claimed on the relevant facilities, as outlined in the Statement of Claim. Furthermore, Justice Abdullah dismissed Dr. Goh's argument about the bank's alleged breach of duty as speculative and irrelevant to his liability. He agreed with IPP that Goh breached his fiduciary duty to the company by failing to consider the interests of its creditors. This duty arises not only when a company is insolvent, but also when it is in a precarious financial state, which was evidently the case by June 2019. However, Justice Abdullah did not fully accept IPP's claim for a specific loss of $10.5 million, citing a lack of sufficient evidence linking this loss directly to Dr. Goh's breach of duty. In July 2024, Justice Abdullah, in his grounds of decision, ruled that Goh Jin Hian is not entitled to relief from liability for paying us $146 million plus interest in compensation for the losses suffered by Inter-Pacific Petroleum, IPP. This decision was based on the egregiousness of Goh's breaches of duty, notably his ignorance of IPP's cargo trading business, a vehicle of fraud, with disastrous consequences for the company. Justice Abdullah stated that Goh's breach of duty demonstrated a level of carelessness or imprudence that undermined his duty of skill, care, and diligence. He emphasized, "The mere fact that Dr. Goh had not been a perpetrator of the fraud did not mean that he was not responsible for its disastrous consequences on IPP. It was through his combination of misfeasance and nonfeasance, in failing to even be aware of IPP's cargo trading business, that the fraudsters were able to use IPP's cargo trading business as a vehicle of fraud in the first place." The judge ordered Goh to pay 332,545 Singapore dollar in costs and 94,301 Singapore dollar in disbursements. In addition to this, Dr. Goh is facing 39 charges under the Securities and Futures Act, which include allegations of manipulating the price of New Silk Route securities on 31 trading days between February and August 2018.